My name is Samir, and I'm a PhD student here at Oxford, and I'm also one of the data consultants for EuroExpert. Today, I'm going to talk about cultural expertise in India. This is going to be more of a presentation on the collaborative project rather than insights on cultural expertise and how arguments related to culture are used in courts. As we speak, there are two very important cases going on in the Supreme Court of India, and hearings are underway right now. One is a case related to a ban on hijabs in school, which is headscarves in schools, and it has reached all the way to the Supreme Court of India right now. And the other is a case on affirmative action for economically weaker sections of the society. And I was following the arguments that the senior counsels are presenting before the courts in both the cases, and there is so much of use of social science in these argumentation, and I just thought that it's so apt to bring that to the attention of this group that is so interested in use of social science in and outside of courts. With that, I will start this presentation. But before I do that, a few differences that I wanted to sort of highlight, differences from other presentations from countries that we have seen, that we saw primarily yesterday. One is that this was a project primarily on case law, and we did not have any surveys of stakeholders, so there's no insight on the basis on who appointed the experts and what usefulness and perceptions of these stakeholders. The other is that as a consequence, court is the only site of cultural expertise that we found or we investigated. We did not look at any other site of cultural expertise. The other is that we focused exclusively on the constitutional courts. So India has two types of constitutional courts, which is first is the Supreme Court of India, which is the apex court and the highest court of appeal. And then there are several high courts, which are again, constitutional courts have the same powers as the Supreme Court, but have a limited territorial jurisdiction, and then their appeals lie to the Supreme Court. We did not engage with any of the trial courts. As you can imagine, it is a mammoth exercise in India, given the breadth of the country. And finally, a very important finding that I'm very proud of is that the data collectors for this project were not professionals or lawyers like most of you, but undergraduate students from my alma mater, Gujarat National Law University, which I will speak to a little bit after this. So yes, this is how EuroExpert India started. It was a collaboration between EuroExpert and Gujarat National Law University, which is the university that I did my undergraduate law degree from. But the reasons for this collaboration was primarily an interest in the theoretical framework of cultural expertise, the interest in acquiring cutting-edge research training, both for myself as well as for students back in India, as well as providing opportunities to students in India who are interested in research. This is the timeline. I was very delighted to join Livia when she was here at Oxford as a research assistant in 2019, and then it was actually at a lunch in my former college, Lineker College, where we were discussing what possibilities of work on India might be there for EuroExpert, and that's how we began this discussion, and then we finalized in April 2022 the conceptualization of EuroExpert India, and then there are the multiple phases that you can see on your screen. Right. So as you know, India is culturally, religiously, linguistically, and to be frank, on any account, very, very diverse. But that diversity is not necessarily reflected in positions of power or higher education for that matter. So we were conscious of that, and what we did was we recruited research assistants on the primary sort of characteristics of or values of diversity and inclusion. We had 9 research assistants who were all undergraduate law students from GNLU, and they belong to these groups. SC, ST, OBC are basically lower caste groups in India, and persons with disabilities. We had Muslim students who are severely underrepresented in higher education, especially in legal education in India, as well as gender and sexual minority students. From a students or research assistants point of view, why was it attractive? Again, everybody in India understands that India is a multicultural country, and therefore there is a lot of need as well as interest in understanding or just trying to inquire into different cultures and how they interplay with one another, and that there is an extensive use of social science knowledge in multicultural litigation in India. They, from the perspective of research assistants, this is what they told me, that they were driven by these two ideas, as well as the opportunity for training in research, experience of working with experts, and visibility. You can see the 9 research assistants: Rishabh, Prasad, Rahul, Atma, Sarthak, Samida, Ronak, Zainab, and Kirtana, and they're there on the website along with leading academics like many of you, including Livia. So it's indeed a very, very good opportunity for them. So our focus, as I said, was primarily the Supreme Court of India. For the first part, we divided the project into 2. 400 case law in project 1 in phase 1 and 400 case law in phase 2. We focused primarily on the Supreme Court of India in the first phase and looked at different types of cases: refugee law, immigration related cases, as well as personal law cases. A lot of personal law cases come before the courts, and you might be aware of the famous Ayodhya judgment that was rendered a few years ago on the title to a piece of land where there was supposed to be a mosque, and then another group said there's a temple that was there before. And in fact, just last week, even though there is a bar by law on reopening or changing the status of places of worship, emboldened by a lot of this right-wing resurgence in India, a lot of groups have now petitioned before various trial courts to look into what was actually at the places of worship before the current places of worship were started. So a lot of digging and a lot of cultural revisionism is on the go in India. So in the first phase, we focused on the Supreme Court of India, and in the second one, we focused on several high courts. As you can see, we primarily focused on, this was not by design, it just so happened that we ended up focusing on north-west part of India, and 2 high courts. This is the Karnataka High Court in orange down here, and this is the Orissa High Court here towards the eastern side. And then there are high courts which look at several of the northeastern states, even though they are 7 in number. Just there aren't 7 high courts, there are just a limited number of high courts that look at all of them. So we also looked at those high courts. Observations, very few. As I said, this presentation is more about the collaborative project rather than insights from it. There is, I already mentioned it, extensive use of social sciences knowledge in litigation in India, whether that was at the Supreme Court level or at the High Court level. There was a lot of use of cultural arguments, especially in relation to matters on religious rights, indigenous peoples' claims, intercommunity property title claims. As I mentioned, the famous case is that of the Ayodhya or Babri Mosque or Babri Masjid, as well as in a great variety of cases ranging from civil to criminal law. There is no set standard of appointing experts. So experts are always appointed on an ad hoc basis. The court, if the court feels like they need the assistance of an expert, they will appoint someone as an amicus or as an expert and to provide sort of assistance to the court. And this point is not just reflected through case law. And another observation I should make here is that the case law that we looked at, we started with 1950, which is when the Supreme Court of India started functioning, and we went chronologically backward. So we went from 1950 all the way to 2020, which is the last case law that we looked at. So this lack of appreciation and sensitivity towards cultural diversity is not just a feature of decades and decades ago, but also on 7th September, this is the case I was just mentioning, and the hearings are still going on even today. There is, a lot of insensitivity or like lack of sensitivity towards cultural diversity. Here, you can see a screenshot of a hearing, a tweet in which Justice Gupta, who is one of the judges of the Supreme Court, is the response to the fact that there are different religious symbols that people wear is that, oh, it's different, they're worn inside, and that's not visible. So there is just no appreciation of the fact that there might be something more meaningful behind this that we should look at. Relatedly, another comment was about use of comparative work to see whether there is scope for wearing headscarves in schools. And you can see the observations of Justice Gupta. How can we compare USA and Canada with India? We are a conservative society. So the mindset is sometimes that we are a conservative society, and therefore we do not need to inquire into, examine, or investigate our cultural practices in courts, which is unfortunate to say the least. I don't want to be held in contempt of a case right now. So the output is that we have 800 case laws from the Indian Supreme Court and various high courts, which will be a part of the Indian chapter of cultural CULTEXP. As you can see, there is a screenshot here, and you go to India. It's not functioning yet, but it will be very soon. We are. I should have added a slide on the challenges that we faced. We faced a lot of challenges with respect to anonymization and adhering to GDPR because, there is no data protection law, or there's no significant and reliable data protection law in India. And there was so much of personal information of individuals in the judgments, and we struggled quite a lot. And we're still figuring things out, but I hope we have been able to cover a great deal of it. I just wanted to leave you all with some potential sort of further research ideas that we can look into. We could look into examination of use of cultural expertise in case law of other high courts. As I mentioned, we looked primarily at Northwest India. There are still older high courts, which are the ones that have been there since from the time of the British. There's the Allahabad High Court, which is the biggest high court in India. There's the Bombay High Court, Calcutta High Court that we could look at. These are significant courts whose jurisprudence is very, very important to be examined. We could, and I would argue that we should definitely look into use of cultural expertise in matters related to personal laws, especially because there is quite a lot of talk about a uniform civil code now in India that would govern every single person in respect of their civil sort of matters and matrimonial matters. Of course, updating the existing Indian database of CULTEXP, which means that the high courts that we have already looked at until 2020, just updating that continuously, as well as other judgments that we may have not included. This could be an academic sort of endeavor to look into the appointment of experts by Indian courts, the law and practice of it. Of course, as I mentioned, it would be a mammoth exercise to look at use of cultural expertise in lower civil and criminal courts. But what would be interesting, in my opinion, would be to look at use of cultural expertise by special courts. We have in India a great variety of special courts that deal with specific subject matter related issues. For example, anti-terror courts or environment related cases before the Green Tribunal or Human Rights Commission, for that matter. So if any of you is fascinated by the diversity India offers, or not just in terms of religion, culture, etc., but also diversity in terms of research opportunities or ideas, do let me know. I'm always around and will be very happy to collaborate or to just discuss ideas with you.